Welcome everyone. We're just waiting for people to make their way in. Apologies for the delay. We do only have one of our speakers so far, but I'm hopeful that our other two speakers will join us soon. Just waiting for the last few to come through. Okay, well, welcome everyone. For those I haven't met before, I'm Faye Appleton. I'm the Director of Membership and Education here at Lincoln's Inn. Otherwise, from the Inn, we've got Charlie Taylor, who's hiding in the background doing the hosting this evening. So before we start, I'm just going to run through some of the arrangements for this evening's session. Our panel are going to speak for about an hour, and then we have half an hour for questions. Please direct all questions to using the Q&A function, which you should find at the bottom of your screen, so that the speakers and I can see those clearly. Can I ask please that you only ask questions that relate to the topic of the lecture, but Charlie and I will stay on for about 10 minutes at the end to answer any more general questions that you might have about things at the Inn and qualifying sessions generally and so on. If you're having any problems with your connection or any other issues, if you can't hear any of us, please do pop that in the chat function. If you drop out of the meeting due to any internet or other connection issues, please do sign back in as soon as possible using the same details as before. Once the webinar is finished, you are free to leave, and we will record your attendance using the built-in reporting function on Zoom, which lists all of the attendees, including when you've joined and left the session. The accreditation of qualifying sessions onto your records isn't an automated process, and the reports do have to be checked, and the qualifying sessions are credited manually onto your record. So do bear with us while we get this done. It may take a week or so for them to appear on your record. If they're not on there within 2 weeks, please do let us know. There might have been an error there. So tonight's lecture is one of our William Stevenson QC Memorial Lectures. Willie Stevenson was a much loved and much missed bencher of the Inn who passed away in 2012. He was a great supporter of education at the Inn, and he would have really enjoyed these lectures, which often provoke some lively discussion. Our speakers for this evening are Tom Hickman QC, Professor Paul Craig, and the Right Honourable Dominic Grieve QC. I'm going to introduce Tom as our first speaker, and then I'll introduce our other speakers when they join us. So Tom was called to the bar in 2003 and practices from Blackstone Chambers. He is a leading barrister in public law, international law, regulatory law, commercial law, entertainment and sports law. Tom is regularly instructed in cases both for and against government and other public bodies. He is also a professor of public law at University College London and regularly publishes articles and blogs and tweets on legal issues. So, Tom, over to you.
Thank you very much. I hope you can all hear me okay. It's a real pleasure to be speaking to everybody. When we planned or worked out what we were going to say between us as the speakers, the panelists today, we knew it was going to be bonfire night, fireworks night, but we also have a reasonably good idea of our respective views on the Miller case, the prorogation case, and we're fairly confident that there weren't going to be any fireworks between us. We have reasonably aligned views, but I think very different perspectives on the case, and we're each going to try and give you a slightly different perspective on the case. What I didn't know, of course, was that it was going to be the first day of lockdown. So I hope you've all got a nice glass of wine as you're watching in, and you're somewhere nice and cozy and locked in and locked down, of course. So obviously the perspective that I bring that's a little bit different from the other speakers on the Miller case is that I was counsel on the case for Gina Miller as David Panic's junior. So I was sort of deep inside the case, and although I have some sort of more general views, I thought it would be at least a good starting point to give you a perspective into the litigation, how the litigation unfolded from a litigator's perspective, which after all is what you all are or soon will be. I mean, I won't pretend that it was a conventional case. But when it started, we had absolutely no idea that it was going to become as big as it became, or as significant as it became. Indeed, we rather thought it would probably, well, to begin with, we didn't think it would happen at all. And then I certainly thought it would probably peter out. I remember the day, and I'll talk a little bit about how it unfolded, but the day that the case was issued, the day after and actually the day the announcement of the prorogation was made, speaking to a colleague of mine who's an academic, and I was had a chat with him about some of the legal issues, and he said to me, "Oh, well, it's nice to be talking to you on the day that the Miller 2 case kicked off." And we laughed about it because neither of us really thought it was going to be anything like as big as the first Miller case, but it turned out that it was. So how did it sort of come about? Well, I mean, there were musings about the possibility of a prorogation from early in the year, being knocked about a bit in the media. Boris Johnson had been asked repeatedly whether if he became Prime Minister he might prorogue Parliament. And I'm not going to go into the details. I'm going to assume that you all know pretty much what was going on and what the case was about, and you will have all read the judgment. So I won't spend time on that. And we wrote him a letter that said, if you become Prime Minister, please will you commit now that you wouldn't prorogue Parliament in the run-up to Brexit Day, which at that point in time was scheduled for the 31st of October. And he, in characteristic fashion, batted all those requests away and refused to answer, and so forth. After he became Prime Minister, he took a slightly different line in correspondence, and he basically said that he had no intention of proroguing Parliament, and the threatened litigation was completely academic. I can see that there's a comment in from somebody who's watching. We're talking about the Miller case. Yeah, I mean, I didn't introduce the subject matter of today's talk because I assumed you'd all seen the flyer. But yeah, the subject matter of the case is the prorogation case, the Miller case. That's what we're going to talk about.
Apologies, Tom. That's probably my fault for not introducing that.
I think most people probably got it. We've only got one question, so I'm sure most people know. We were told the case was academic, and indeed the day before the announcement that the Prime Minister had asked or was going to advise the Queen to prorogue Parliament, we received a letter still maintaining that the case was entirely academic. So we were preparing, but no one was actually was thinking that there was going to be a prorogation. In fact, I remember David Panic expressing the view before the summer that he didn't think it was very likely at all. So we were very surprised when it was about, I think, the 25th of August, when the newspapers reported that Boris Johnson had advised the Queen to prorogue Parliament. Unfortunately, at the time, I was on holiday away with my family, and David was in Botswana on safari and was completely uncontactable. And I was confronted immediately with an extremely urgent, potentially very high-profile legal claim to bring. Fortunately, had done some preparatory work, so the grounds were, broadly speaking, drafted, although we had to amend them. And I had to go and find some internet connection. I had to get in touch with the solicitors. I had to tell them that we had to issue proceedings that day. So we had about 5 hours to get the claim finalised, get a statement from Gina Miller, and get everyone and everything over to the Administrative Court office before 4:30 to get the claim issued. because we didn't want any time to slip by at all. And in fact, to begin with, we rather hoped that we would be able to issue the claim before any order in council was actually made by the Queen, proroguing Parliament or setting up a commission to prorogue Parliament, because we were fearful that once the order in council was made, that there'd be an additional hurdle for us, because there are some suggestions in some academic writings that the Queen has a residual discretion to refuse a Prime Minister's request to prorogue Parliament. And if that is the case, then it might have been a non-justiciable matter. So we fired off a request to the palace: please don't make an order in council. You've received unlawful advice. Unfortunately, the order in council had already been made. Jacob Rees-Mogg had flown up to Balmoral that morning, I think it was a Wednesday or Tuesday morning, and obtained the order in council from Her Majesty the Queen. And so we had to challenge the order in council as well as the advice to prorogue, and we had to get the claim in really quickly. We knew people would be queuing up to litigate, and there was a claim already on foot in Scotland, although that hadn't been heard. And so we had to move really, really quickly. We managed to do that. We got the claim issued. So, and that's important. It's really important that you get in first. Really, really important that you get in first. It removes a number of annoying and potentially complicating practical difficulties. I won't go into those sort of things now, but we could talk about them later. And the other thing is we had to try and set up a hearing as quickly as possible, and therefore had to communicate. I think we actually wrote directly to the Lord Chief Justice, who issued an order that day directing the Secretary of State to provide their proposals for hearing of the case the following day. So we had to move very, very quickly. There were no procedures really for moving at that speed, particularly in a vacation. You just have to communicate in a sensible way with the court. We did get the case on pretty quickly, and we lost, hands down, on everything. Non-justiciable. Even if it wasn't non-justiciable, there's the reasons that were given for the 5-week prorogation in the run-up to exit day were sufficient, and we lost hands down. The case in Scotland came on after that ruling, and it really, I think, changed the game. The Scottish Inner House ruled that the prorogation was unlawful, said that the Prime Minister had acted with an improper motive in seeking to stymie Parliament, scrutinising and holding the government to account in the run-up to exit day. And so the stage was set for quite a big case in the Supreme Court. The Supreme Court sat with 11 justices for only the second time, the first being the first Miller case. And by this time, Parliament had actually been prorogued. So there wasn't, part of the prorogation had already happened. And I'll return to that in a minute. And there were obviously a number of parties. The Cherry parties from the Scottish case were present, and a number of intervening parties. And of course, as you all know, we won in the Supreme Court. Now, in the blurb, the handout, the flyer, whatever it is that's been produced for today, I think I said I would talk a little bit about the litigation, and I'm happy to talk more about that, litigation strategy. I'm happy to talk more about that in questions, but I also want to just very briefly address this question about whether or not the court was acting politically in this case. And I just wanted to make some short points about why, as I see it, it's really incorrect to try and characterize the ruling of the Supreme Court as being a political judgment or an improper interference in politics. What are these 3 points? Well, first of all, there has been no other prorogation of that length, 5 weeks, or anything approaching it in modern times. Prorogation normally just happens for a few days. It's a way of resetting the parliamentary calendar, bringing in a new set of legislative, new bills or legislative proposals that will be advanced later in the session. So it's really a technicality. Why is that significant? Well, that's significant because this is not going to happen every year. It hasn't happened for decades. It will probably never happen again. So the courts, one thing the courts weren't doing, they weren't acquiring to themselves a power that is of any real significance in modern constitutional practice. They are not now in a position to sort of regularly decide whether Parliament can be prorogued. It's almost certain that they'll never review another prorogation, I would say. Certainly very unlikely. So it's not a power grab. Secondly, as I've already mentioned, by the time this actually came onto the Supreme Court, the prorogation was half over. So the ruling itself meant Parliament came back just for a couple of weeks. Now, what's the relevance of that? Well, that tells you that, and that was clear to the court when it handed down its ruling or when it heard the case. So it obviously wasn't ruling the way it did, really in the expectation that it would have any significant impact on the political agenda. Okay, it knew that it was establishing a point of principle, and it wasn't really going to have any political consequences. Thirdly, and I think this is more of a slightly more of a jurisprudential point, but the court had to decide the case one way or the other. Okay, so it either had to decide that, as the divisional court had done, that the prerogative power was either formally or effectively substantively non-justiciable, and therefore that the Prime Minister can decide to suspend Parliament for very long periods, not be subject to accountability to Parliament for long periods, or the court had to say, no, that was wrong, and it had to intervene. But by intervening, as I've already said, it wasn't acquiring really power for itself. It was primarily empowering Parliament and ensuring that Parliament could sit and hold the government to account. So ultimately, the court had to allocate power to one or other branch of government. It either had to allocate the power to Parliament or to allow the government to have this previously unappreciated, very extensive power to control the length of time that Parliament sits for. And the court decided that it would give that power to Parliament, but it had to choose one way or the other, and whichever way it allocated the power, it was going to have to, in a sense, make a political decision. So I think that the Supreme Court can and should be acquitted of allegations that it was acting politically or it was seeking to intervene in the political process. So those are really my comments. I'm looking to see if either of the other two panelists are here yet. I can't see their names. Faye, is there anyone else? Otherwise, I'll just keep going.
No, I think you're going to have to busk for a while, I'm afraid.
Yeah, well, I could hours now.
We can invite our students watching to send in some questions for you at this point if they have any. But do carry on, and then I'll let you know if there are any questions.
Well, let me talk about. There's one other aspect of the case which I think is particularly interesting, and this is the use that was made of parliamentary sovereignty. And well, there were two constitutional principles that the Supreme Court essentially identified and said it was giving effect to. One was parliamentary sovereignty, and one was what it called the principle of parliamentary accountability. And this is I think interesting for a number of reasons. Let's take parliamentary sovereignty first. So parliamentary sovereignty, in its classic Diceian form, is simply a rule, as Dicey expressed it, that Parliament can make or unmake any law that it sees fit. An act of Parliament must prevail over everything, and it cannot be set aside by anything. That's the rule, the legal rule of parliamentary sovereignty. So it's not obvious what parliamentary sovereignty has to do with the Miller case, or what role it had to play in the Miller case, because the prorogation wasn't overriding, or it wasn't in conflict or tension with any act of Parliament. So how was parliamentary sovereignty in play here? Well, around the principle of parliamentary sovereignty, a cluster of other principles, or examples rather of cases where the courts have intervened to ensure that parliamentary sovereignty isn't chipped away at or evaded by executive government. And you can identify a number of different examples of that. One is, for example, the fact that the courts will no longer recognise or extend prerogative powers that interfere with rights. They say, no, that's got to be, if you're going to interfere with any rights, that's got to be done under parliamentary power. It doesn't, strictly speaking, constitute a confrontation with the principle of parliamentary sovereignty, but is very closely associated with the principle of parliamentary sovereignty. It's recognising that Parliament is really the body responsible for legislating. Parliamentary privilege. Parliament has certain privileges where the courts won't interfere with certain of its own processes. And again, that is said to derive from parliamentary sovereignty, case of Picking. And there are other similar principles that cluster around the principle of parliamentary. I can see Paul's here, but I'm now going to finish my 2 points, so Paul's going to have to wait, I'm afraid. Hi, Paul. Lost my train of thought. Oh yeah, so what was parliamentary sovereignty having, what role was it playing in the Miller case? Well, the point was this, that if you're going to have a principle that Parliament is the apex institution in the Constitution, and it has this amazing power, then that wouldn't be worth anything if a government could come into power, vote itself loads of money, which actually is not looking quite as implausible as it maybe looked last year, given that in the Coronavirus Act, the government voted itself access to something like £240 billion in a single clause. But so vote itself loads of money and then suspend Parliament for 5 years. And that would be it. And Parliament might have sovereignty, but couldn't do anything. So the court said, well, look, as prorogation rubs up against this principle of sovereignty, and therefore there has to be a point at which we're able to say, no, this goes too far, in order to ensure that parliamentary sovereignty is meaningful and capable of exercise. I know Paul's here, but I did mention parliamentary accountability. Sorry, Paul, I was just busking while we were waiting. So I'm now just going to quickly finish what I was saying. So the other principle that they identified was the principle of parliamentary accountability. And that, if anything, is even more interesting because it hadn't really been recognised by the courts as a positive principle of public law. Before then, the court noted that this principle has played a role in a number of legal cases where the courts have refrained from interfering in executive action because of the principle of parliamentary accountability, that ministers are accountable to Parliament primarily, and therefore the courts have been reluctant to intervene, have given a wide berth to decisions. But in the Miller case, they said, well, actually, logically, this principle can have some positive aspect, and therefore prorogation rubs up against that principle as well. Now, interestingly, when we first looked at the case way back in June last year, David he said, well, look, this is a violation of parliamentary sovereignty. You know, we've got to argue this case on the basis of parliamentary sovereignty. I said, well, it's not really interference with parliamentary sovereignty, it's parliamentary accountability. And we sort of rode these two horses all the way through the case. So I was particularly pleased that in the final judgment, you know, sort of both our perspectives were somewhat vindicated. Anyway, right, I will now shut up. I've spoken for too long, and I will listen to my
Not at all. Thank you very much, Tom, and for filling in there as well. So I'm now going to introduce our second speaker. So Professor Paul Craig was educated at Worcester College, Oxford, where he subsequently became a fellow and tutor in law in 1976. He was appointed to a readership in 1990 and has been Professor of English Law at St John's College, Oxford since 1998. He was made an honorary QC in 2000 and an honorary bencher of Gray's Inn in the same year, but we won't hold that against him. You're very welcome, Paul. Over to you.
Thank you so much. I apologise for being late, but it was fortuitous that the lateness was due to the fact that I was taking part in a Bonavero webinar about a really enjoyable Bonavero webinar with Cato Reagan and Helen Mountfield and Lord Chief Justice, which was about the Lord Thomas, which was about the Joshua Rosenberg's book, Enemies of the People, ? How Judges Shape Society. which is a terrific book. So let me just give it a plug to all those who are interested in judicial reasoning. And of course, both Miller 1 and Miller 2 feature in the book, they're sort of bookending chapters, chapter 1 or chapter 2 and the final chapter about Miller 1 and Miller 2 respectively. So that was the reason that I was late, and I apologize to Tom for not being able to hear most of his presentation. In any event, what I'm going to do this evening is I'm not going to attempt to give a traversal, as it were, of all the legal issues arising in the case. I'm actually going to share my screen, and I'm going to focus on one particular part of the case. And this was about, and just to ask us to think quite hard about one particular part, because it got lots of play, particularly, well, partly in the actual hearing, but also more so in the academic commentary thereafter. And it was about the relationship between prerogative and constitutional convention, and in particular about prerogative, constitutional convention, and justiciability. And this featured heavily in the critique of the Supreme Court's decision. Now, my own views generally about Miller 2, for anyone who's interested, were set out in a lengthy public law article. I'm one of the academics who think that the judgment was absolutely right and that the critique was misplaced for reasons that I explore in detail in that article. But there was a key dimension to the argument that I, notwithstanding the length of that paper, did not explore fully in the article because of exigencies of space. And for anyone who's interested, it's explored in a forthcoming chapter in the Supreme Court Yearbook, where there is a further round of academic exchange between myself and John Finnis, who I respect, but we take starkly different views about this. And that did enable me to explore in more detail the relationship between the prerogative and constitutional convention. And I just want to share some thoughts about that, because I actually think it's a really interesting issue conceptually, and one which is still imperfectly understood. So let's just set the critique, be clear about the critique at the outset. The critique was that the Supreme Court subjected constitutional conventions concerning prorogation to JR, to review, and transgressed the boundary, hence transgressed the boundary between what was justiciable and what was not justiciable. I don't think that that's correct. I think it's misplaced, but we need to unpack the argument in some detail in order to understand why. And I think actually one of the fascinating things about being a lawyer, whether it's an academic lawyer or a barrister, is that you're forced to think hard about things and to drill down into first principles, particularly when you get a big case like Miller 2. And I think it's really important at the outset, if we clear the ground and understand the basic precepts which are applicable in this area. Now, this is all just standard fare, and I just set it out here by way of an introductory slide. So the prorogation is a species of prerogative power. It is not, and this is actually quite important, it's not a constitutional convention. It's a species of prerogative power, but a convention may impact, doesn't have to, may impact on the way in which the prerogative power is used. And I just emphasize here, you can have prorogation exercise where there's no constitutional convention at all. And indeed, much of the criticism of Miller 2, or at least part of the criticism of Miller 2, is based on descriptive assumptions about what the Constitutional Convention said, which I think are unsustainable empirically. But in any event, I'm not going there at the moment. But if anyone has any questions in that respect, I'm happy to take them. Prerogative power is subject to legal constraint. The courts determine the existence and the extent of such power, and post-GCHQ adjudicate also on the manner of the exercise, subject to limits of justiciability, which I'm going to discuss below. What was notable, of course, about GCHQ is the parity of treatment in that case accorded to the review of statutory and prerogative power. That was the guiding principle, normative principle, which informed the court's judgment, that the executive should not, as it were, have any particular advantage in seeking to use a discretionary power which was based on the prerogative rather than on statute. Subject to issues of justiciability, the two were to be treated in the same way. Now, whether the executive does actually have the prerogative power in question may turn on a plethora of issues, including the meaning of the particular prerogative, past cases, historical evidence as to the providence and reach of the prerogative, and constitutional conventions may be relevant insofar as they exist and touch on the particular prerogative power. Now, I want to draw a distinction here, which is actually, I think, quite important. And actually, like all distinctions, when you see it, you think, well, that's pretty obvious, isn't it? Well, I think it is pretty obvious, but people have lost sight of it, notwithstanding that. So I want to draw a distinction between judicial review and conventions in relation to swords and in relation to shields. And I think that there is much confusion in both respects. So let's begin with judicial review and conventions in relation to swords. The UK courts have made clear that constitutional conventions are not legally binding and cannot be legally enforced. That was made unequivocally clear in Miller number 1, where the courts stated unanimously, I think, in this respect, that failure to adhere to the Sewell Convention could not in itself be a cause of action and hence the foundation for a legal action. And in that sense, it could not be a sword. Now, whether that should be so has been debated amongst academics, but I'm not going there, as it were. I'm not taking issue with that statement of legal principle by the Supreme Court. But it's assumed by critics of the Supreme Court in Miller 2 that because Miller 1 said that constitutional conventions are not a sword, that therefore in some way there's no legal action when the executive exercises prerogative power in breach of a convention. So they reason from the assumption, the premise, that a constitutional convention is not per se in and of itself a sword, it's not a cause of action in and of itself, that therefore there's no legal action when the executive exercises a prerogative power in breach of the convention. That is a simple and rather bad non sequitur. It does not mean that the ministerial action is immune from review. Why not? It can be, the point made at the tail end of the previous slide can be readily demonstrated. Let's imagine that there's a constitutional convention which provides that a prerogative power can only be used in situations A, B, and C. The executive breaches the convention by using it in situation X, which is quite different, we will assume, from A, B, and C. Now, Miller number 1 tells us that breach of the established convention does not in itself render exercise of the prerogative in situation X unlawful. It's not a cause of action in and of itself. But the ministerial action is still open for review in accord with established criteria relating to the existence, extent, and manner of exercise of the prerogative power. Let's not forget, I repeat it once again, the action for judicial review is an action for judicial review of the prerogative power, in the same way that an action for review is an action for review normally of a statutory discretionary power. Now, it may be that the review of the prerogative power can withstand scrutiny under the normal criteria for judicial review, even though it was in breach of a convention. It may be that's possible, but it may also be that that's not possible. The reviewing court may decide that deployment of the prerogative in situation X overstepped the limits of prerogative power, that it impinged on rights, or that it was unsustainable in relation to the manner of its exercise. And the convention may be part of the backstory or the backstory considerations that informs that conclusion. So the mere fact that a constitutional convention is not a sword and not a cause of action in and of itself does not mean that an executive use of the prerogative power prorogation, which is in breach of a constitutional convention, is unreviewable. And just to drive home that point a stage further, just to drive it home, the fact that the Constitutional Convention thereby breach might not be justiciable in the sense that it does not embody enforceable legal rules in its own right does not therefore immunize the ministerial action from the normal rules of legal scrutiny of prerogative power. And just to set that out in two simple steps, which I think are compelling. Example of scenario number one, there's no constitutional convention and the minister exercises the prerogative power for reason X as elaborated above. It will be open to review on the normal grounds concerning existence, extent, and exercise of prerogative power. Example number two, or scenario number two, is the same as scenario number one in all respects, save for the fact that there is a constitutional convention of the kind set out above. The courts will not enforce the constitutional convention. That does not, however, immunize the minister's exercise of discretion from the normal criteria of judicial review. To suggest the contrary would be literally constitutionally absurd. The same ministerial action to activate the prerogative power for reason X would be immune from the ordinary incidents of judicial review in cases where it had, in addition, violated a constitutional convention. And the law may sometimes be an ass, but it's certainly not an ass in these circumstances. So let me turn in the time I have available just to the other side of the coin, which is judicial review and convention's shields. The critique of the Miller decision, Miller 2, is based, certainly as advanced by John Finnis, on the assumption that there's a strict dichotomy between law, which is justiciable, and convention, which is non-justiciable. That strict dichotomy is highly problematic. Now, that's clear from existing literature, been articles by Alan Elliott, by Ahmed Albert, Perry, a joint paper by all three writers, and by Nick Barber. And they all question the plausibility of that strict dichotomy. And they all make clear that conventions are indeed legally cognizable in certain circumstances, as is clear from existing case law. The relationship between prerogative convention and judicial review in relation to shields nonetheless warrants a bit more scrutiny. Sorry. For the following reason, and again, we drill down to, I think, a pretty fundamental point of principle. It's this: the existence of a constitutional convention pertaining to prerogative power does not, ipso facto, immunize it, the convention, from consideration when we ask whether the judicial controls over prerogative power should be invoked. If that were so, constitutional conventions thus conceptualized would become generic shields, such that they would be generally immune from consideration where there is a legal action concerning a prerogative power. That is constitutionally untenable. There is no warrant for regarding constitutional conventions as generic shields. A particular constitutional convention might, of course, be deemed by the courts to be non-justiciable, judged by its subject matter. But constitutional conventions as a generic category are not immune from consideration, nor does the content of a convention have canonical status in any such judicial review action. The contrary argument would render constitutional conventions superior in this respect to formal law, in the sense that it would mean that they could not be reviewed in the context of any legal action. It would, moreover, per se nullify legal controls over prerogative power if the mere placing of the convention before the court were to signify that it could not be questioned when determining the limits, extent, or manner of exercise of prerogative power. So, simple example, there's a constitutional convention relating to the meaning, limits, or application of a prerogative power, which informs the way in which the executive uses that power. There's a legal challenge to the use of the prerogative power. Now, the challenge may raise definitional issues as to the fit between the convention and the meaning or reach of the prerogative power. It may be argued that the exercise of the prerogative in accord with the convention would impinge on rights, or it may be contended that the purpose of the particular convention does not accord with the purpose for which the prerogative power relates. None of those issues, in my view, should be per se ruled out of bounds for the court. Constitutional conventions, in my view, do not constitute generic shields. The fact that a particular constitutional convention might be deemed to be non-justiciable is one thing. That is wholly different from suggesting that constitutional conventions, by their generic nature, are ipso facto off the table when one considers a judicial review action. Thank you very much indeed for listening, and I will now stop sharing my screen and pass back to Faye. Thank you.
Thank you very much, Paul. That was hugely informative, absolutely fascinating. I'm now going to introduce our final speaker, the Right Honourable Dominic Grieve, QC, was elected as MP for Beaconsfield in 1997. Prior to that, he was a practicing barrister, a councillor for Hammersmith, and was in the Territorial Army. He was appointed to the opposition front bench in 1999 as spokesman on constitutional affairs, and then as Shadow Attorney General in 2003. In 2008, he was made Shadow Home Secretary and then Shadow Justice Secretary in 2009. After the general election in 2010, he was appointed Attorney General, holding that office until July 2014. As Attorney General, he dealt with public law matters in the Supreme Court, the European Court of Justice, and before the European Court of Human Rights. He now practices from Temple Garden Chambers. Dominic is also a visiting professor in law, politics and human rights at Goldsmiths, and a trustee of the Oxford Centre for Islamic Studies, and a member of the Council of Management of the Ditchley Foundation and president of the Franco-British Society. He is also a bencher of Middle Temple. Dominic, over to you.
Thank you very much. And can I first of all apologise, but due to a glitch on my part, I didn't have the necessary information I hadn't checked to join you. So I missed most of Tom's presentation as I scrabbled around to find the means of coming into this webinar. So my apologies that I missed what he said, or most of what he said, like Paul, and I hope I don't repeat myself. When we decided to do this webinar, it was decided we would split, because we don't just want to repeat ourselves what we had to say. And it was thought that what I might focus on were two issues. One, the political dimension. I know this may sound a bit odd for lawyers, but I think there was a political dimension and a factual political dimension which had a very heavy bearing on the outcome of this case. It's important to understand it. And then secondly, perhaps some comments just more generally on where it leaves both constitutional conventions and prerogative powers, which I think is quite an important issue, which Paul has touched on. So just to start with the political dimension for a moment, it's worth remembering that if you had gone to the House of Commons and said to a group of parliamentarians 3 years ago, do you think it is permissible for a government to prorogue Parliament for 34 days? I think the answer that you would have had unanimously is that people would have looked completely aghast and said, what on earth are you talking about? Because the reality is that proroguing Parliament for a long period is something that simply has not happened in modern times, even if the prerogative power of prorogation undoubtedly exists and indeed continues to exist today. It's true that Charles II prorogued Parliament for lengthy periods because he didn't like Parliament to sit. And it's also true that there are some statutory restrictions and practical restrictions on proroguing Parliament for long periods, namely restrictions which say that Parliament must at least sit within certain set periods. And of course, Parliament does have to vote supply twice a year, so that effectively, if you prorogue Parliament for more than 6 months, the government is going to run out of money. But the idea that you could prorogue Parliament for any other purpose other than two in modern period would really have been unheard of. And those two are very simple. One is that you prorogue Parliament to start a new session. Experience is that the prorogation of Parliament in those circumstances is normally you prorogue Parliament on a Thursday and Parliament sits the following Wednesday. The advantage to the government is it starts a new session. That can have constitutional implications in respect of bringing back, for example, legislation that has been blocked by the House of Lords and forcing it through. So it's a mechanism that a government can legitimately use, including potentially bringing a session to a premature end, or at least not the end that they had previously advertised the end date as being, in order to start a new session. That would appear, and I think most parliamentarians would have said that was a perfectly permissible thing to do. The second one is that it's been used by some governments to prolong general election periods. General elections are supposed to take place within a certain set days of dissolution. I think it's 25 days of the dissolution of the House of Commons, and that's important so that the country shouldn't be without a parliament at all. But sometimes it has been convenient to government to try to prolong the election campaign. John Major's government did it over the Easter period by starting off with a short, perhaps 10-day period of prorogation, and which is then, Parliament is then dissolved, and then the 25 days kick in. But those are the limits of the previous usage. But during the course of the campaign for electing a new Conservative Party leader in the summer of 2019, And because of the problems that Theresa May had been experiencing as Prime Minister, and in particular, in the passage of the first piece of legislation where the House of Commons had seized control of the order paper and compelled the Prime Minister to seek an extension of the Article 50 period from April, the 12th of April to the 31st of October, which had taken place earlier in the year. The first time you started getting mutterings, and I don't know where they first emerged from, of ministers. I seem to remember Dominic, the current Foreign Secretary, saying this, saying, frankly, if Parliament is going to behave in this, or the House of Commons is going to behave in this disgraceful fashion, why don't we just prorogue it until we can get ourselves out of the EU? And I have to say, this was rather invoking a bit of the will of the people in all this. We are entitled to do this, and Parliament is, and the House of Commons particularly, is blocking us. But you remember that when during that campaign, Boris Johnson was asked about whether he thought that that was a proper thing to do. He expressed reservations about it. But in fact, what happened is that in early August, once he got into office, rumours started flying around very quickly that in fact the government was considering using prorogation as a weapon to remove Parliament and thus prevent Parliament from interfering in its own negotiations with the EU about exit, including, if necessary, leaving with no deal. And I am quite satisfied that that was happening very early on in the Johnson government. If you go and look at the judgment of the Supreme Court, you will be able to see that the Supreme Court was able to note that the government was insisting in late August that it had no plans to prorogue when the challenge was being made to it in the Scottish courts, when in fact it is now clear from the very limited number of documents that were ever disclosed about the background to prorogation on discovery in the judicial review case, that in fact the government had started talking about this as early as the 15th of August. It had been effectively signed off 24 hours later by the Prime Minister, and by the 23rd, they were actually planning the details of how the prorogation was going to take place. So it is impossible to escape the conclusion that the government lied. Indeed, it's difficult to escape the conclusion. The Supreme Court glossed it, that actually the government misled the Scottish courts about its intentions in late August. I've always been interested to know how that succeeded in getting into its submissions to the court on the two occasions that the case appeared. So you'll be aware the Scottish case started on a sort of queer TMET basis, because it started even before prorogation had been contemplated, because it believed that it wanted to get a definition of whether prorogation was acceptable or not. The English litigation started once it had been announced that prorogation was going to happen. I think the government miscalculated on the politics, because actually, precisely because there was this belief that they were going to try and prorogue, members of Parliament got together during the summer vacation in the middle of August and plotted, a group of us, to pass what has since been known as the Benn Act, and we succeeded in doing that even before the government could implement prorogation in early September. But we weren't able to stop the prorogation taking place. Indeed, the House of Commons has no power to do this. I suppose the only power the House of Commons could have tried to do would have been to bring the government down on a motion of no confidence, which was in fact going to be impossible prior to the 9th of September prorogation taking place. Those background facts, I do think, when you go and read the judgment, have quite a considerable bearing on the way the court approached this. Because, as I agree with Paul Craig about this, the fact that a convention as to how prorogation was being breached, you could argue that government had stepped outside the conventional use of prorogation. The point, surely, was that prorogation as a prerogative power was always potentially susceptible to judicial review. And indeed, the clarity of the Supreme Court's judgment on this is absolutely unequivocal. It may be that there are some forms of prerogative power which the courts will decide, even when they look at it, that they will not interfere, because in the way that the Lord Chief Justice decided at first instance, this is about high policy, which the courts can't possibly interfere with. But it doesn't mean that the courts can't review the power, because a prerogative power is common law power recognized by the courts as existing. And without that recognition by the courts, there is no power. That, I think, is probably a pretty clear definition of what the rule of law consists of. And in that case, it really goes back a very long way. And of course, once the courts started looking at the exercise of the power, then you can legitimately ask the question, is this power being exercised in a way that is essentially not so much in conformity with the Constitution, but does it have regard to all relevant interests? Paragraph 30 of the judgment is very clear about this, just worth reading out. Before considering the question of justiciability, there are 4 points that we should make clear. First, the power to order the prorogation of Parliament is a prerogative power, that is to say, a power recognised by the common law and exercised by the Crown, in this instance by the sovereign in person acting on advice in accordance with modern constitutional practice. Then they exculpate the Queen, quite rightly, from responsibility. In the circumstances, we express no view on that matter. That situation does, however, place on the Prime Minister a constitutional responsibility as the only person with power to do so, to have regard to all relevant interests, including the interests of Parliament. And of course, when you get to the end of the judgment, where the Prime Minister is eventually damned, is that they say that he had no regard to the interests of Parliament and no regard to the interests of the absolutely fundamental principle of our United Kingdom Constitution, which is parliamentary sovereignty. And that is why the judgment went the way it did. When the litigation was started in Scotland, I was a bit dubious, particularly because it wasn't at all clear to me that you get a declaration in anticipation of a constitutional crisis brought on by prorogation. But I have to say that the moment I changed my mind was when I realized that the government could not submit an affidavit in explaining their reasoning for prorogation, because in fact there was nobody available to tell the truth, which was that it was a deliberate ploy to sideline Parliament, and in particular the House of Commons, during the difficult run-up to our departure from or possible departure from the EU on the 31st of October. And that ultimately, in my view, is why the judgment went so clearly the way it did, and a unanimous judgment of the Supreme Court. Where does that leave conventions and prerogative powers? Well, I suppose the answer I would simply make to that is that if you start using prerogative powers outside of conventions, then the chances of the prerogative powers not being scrutinized and potentially challenged or overturned in court starts to go down very dramatically. There are a limited number of prerogative powers around at present, and of course history, as we have seen, both in the case of Miller 1 and Miller 2, is that on the whole, and for reasons which I think are rather valid, I suspect the courts are not very comfortable with them in the context of modern democratic government. That's not to say that they don't have a function and a purpose and indeed a legitimacy, but I think it is to say that if governments start acting in such a completely cavalier attitude in respect of a prerogative power as the Prime Minister did in late August of last year, then it's highly likely that somebody will and both define the power, or in some circumstances, as we saw with Miller 1, simply say that the power which the government believed it had is in fact overridden by other considerations within our Constitution. Thank you very much.
Thank you very much, Dominic. And you did an excellent job of not talking across each other there, so well done. So I'm going to ask Paul if you'd like to come on to camera as well, and we will take some questions. We've had quite a lot already. I'm going to try and get through some, and I must confess, as a non-lawyer, I don't necessarily even always understand the questions, so I will do my best here. But we've had a question from Alex, which kind of follows on, I think, from what you were sort of finishing up with, Dominic, which was so Alex has said that both the Miller cases arose from uncertainty as to the limits of different prerogative powers. And Alex suggests, should the prorogation power, and indeed all prerogative powers, now be converted into statutory powers so that their scope and limits can be properly defined by Parliament rather than piecemeal by the courts? Anyone want to have an initial go at that one? Stunned silence.
Well, I will have a start attempt, and then Tom and Paul can contradict me. There are great flexibilities in the UK Constitution, and I've never felt uncomfortable with prerogative powers, although it is true that historically we have watched their diminution over time. And I don't think that is a bad thing. If you replace them with statutory powers, the trouble is they can then become quite sort of they can be worse than prerogative powers limited by convention. So I'm not completely certain that it's the right way forward. Others may disagree. I mean, the other suggestion is that you should just abolish most of these prerogative powers and say, in that sense, you might then have to replace them with some statutory powers. Alternatively, they would have to be things which are triggered by Parliament and which you've got parliamentary approval. And that would be an alternative way forward. But as I say, if you're going to have these powers, they have to be exercised within the limits of convention. And whilst convention has the advantage of flexibility within certain parameters, when you step so clearly outside it, as happened with Miller 2, I think you're in very dangerous territory. Miller 1, I actually see a completely different. Miller 1 was the government had a perfectly arguable case in Miller 1. I happen to think it was mistaken, but Miller 1 was about the complex interplay between treaty-making powers and changing United Kingdom statute law by the consequence of resigning from a treaty. And I think that decision was absolutely correct as well. But that was quite an interesting esoteric point. I actually think the prerogative case could not have been more starkly clear that the government was in fact acting grossly improperly.
Paul?
That's just very. I'm going to respond to that last point, but I'll let Paul go.
No, I mean, Tom, you go.
Well, I mean, it's nothing to the question. I was just provoked by. It's interesting because I always felt that the first Miller case was a much stronger legal case.
Interesting. Yeah.
I mean, the first Miller case, I mean, was the starting point of that case was a blog that a couple of academic colleagues of mine and myself wrote a few days after the referendum, and we set out the argument. And it seemed to me, we discussed it over the weekend, and it seemed to me that you couldn't leave the European Communities Act as a sort of dead letter. But the second Miller case had so many difficulties because it was just this void of law, and it wasn't clear, what legal principles you could attach to the question, how you could judge it. And the point that I made when I was talking is that the court eventually identified these two principles: parliamentary sovereignty in a sort of wide sense, and parliamentary accountability. But it had to do quite a lot of work to do that. I think it was right. But from a legal perspective, I felt, and I think this was the view of the team, the second case was we're writing off a big ask than the first case. But anyway, sorry, that wasn't even answering the question.
So just in relation to the question about putting it on statute, it's quite interesting, quite fortuitous. I've just had a very talented doctoral student who's just completed a thesis about prerogative power and third source powers. And one of the things he considers towards the end of the pieces is exactly this issue, the viability of putting them onto statute. And as Dominic intimated, you might try and do it, but actually even if you wanted to do it, it's considerably more difficult as a matter of forensic drafting than you might think. I mean, putting it briefly, you get caught between a rock and a hard place in the sense of you either leave them so abstract that you end up with a massively broad statutory discretionary power, and you're just going to have the same issues about what the limits of that are. Or you try and make the statute much more granular, much more detailed. And then once you start doing that, and just put aside prorogation as a power, as a prerogative power for the moment, if you're trying to do that with something like a treaty-making power, trying to define in detail the kind of metes and bounds of when you can use your prerogative power to make a treaty just becomes, you either leave it very abstract, or if you try and make it very detailed, it becomes a nightmare for drafting and application.
Well, I think, Alex, the answer is no then. So, Tom, we've had a couple from you about a couple for you, sorry, about how surprised were you at the unanimous decision in the Supreme Court, and also particularly that it obviously as a reversal of the first instance decision, and whether you changed your approach or strategy between the first decision and the Supreme Court case.
Okay, so we did change the strategy a little bit between the two levels, and there's an interesting, Paul Craig features in this little bit, this story, because basically there were two ways you can run the case. You could say, well, the effect of the decision to prorogue for 5 weeks, it interfered with these principles and wasn't properly justified. Or you can look at the purpose, and you can say, well, the purpose was an improper purpose. And at first instance, we ran it very much as the effect. And then Paul and another academic, Mark Elliott, wrote some really excellent blogs on the first instance decision, and said, look, this is a purpose case, and they've got no case on their motives. They won't no one's prepared to put their name to a witness statement. And so we said, look, let's just go for it. We've got to put this at the forefront. They're right. This is the point. So we put that. We're always running both points, but we put it at the front of our case. And it's interesting. You can probably go back and look on YouTube. But if you watch the way David presented the case in the Supreme Court, he started off by saying, this was the purpose. They haven't justified this. The purpose is clearly improper, such and such. And the pushback we got from the court, I think Lord Reed, very early stage, said, well, isn't it more about the effect of the and then David's submissions became, the purpose is clear, but obviously the effect is also really, we almost shifted the emphasis even within the hearing itself. But that's what you have to do. You read the judges, and you have to read your judges and play to the strengths and the cards you've got. Were we surprised it was unanimous? Yes, absolutely. I mean, when we went in and we got the result, another interesting aspect of this is there's only been 2 cases in my career where it's been a reserved judgment, and I've not had the judgment in draft before, because it's common practice that the judges will send out the judgments before. The first Miller case, they gave David, myself, and Gina the judgment 2 hours before in a locked room, because it was price sensitive. It was affecting the markets. But we got it in advance. But in this case, we didn't get the judgment in advance. So every lawyer was sitting in the Supreme Court, and nobody knew the result, which was completely the right thing to do. And it's horrible if you know the result, walking into the room, everyone looking at you, trying not to show anything in your face. None of us knew. So when Baroness Hale gave her little presentation, and she talks about walking in blank piece of paper, and she said it was a unanimous judgment. I mean, everyone was just gasped, you know. And we all looked at each other when that had finished, and we just turned to each other and was, wow, all of us.
Tom, could I ask?
We were blown away.
Could I ask, Tom, could I ask you, in apropos that question, I mean, to some extent you've answered it already, but just to push you a bit further, I mean, my sense, I mean, I remember it was so dramatic. I mean, it was even more, I was in the States at the time doing some teaching. So 10:30 in the morning was 5:30 in the morning. So I was sitting there with my cup of coffee at 5:30 in the morning as Baroness Hale and Lord Reed came in. And, you know, when the opening, I just kind of punched the air and said, yes, you know. Anyway, what I want to ask is, I was surprised about the 11, the unanimity, but I was also, I mean, when people at the law school in the States asked me about that, which they did kind of over lunch that day, my take on it, but it may be wrong, was simply that it wasn't fortuitous, that they realized how important this was. And they didn't want a judgment. It's not just that they wanted unanimity, they didn't want a judgment which has got 3 dissents, which have got, you know, a whole 30-page different take on it, because of the constitutional significance of what they were saying. And of course, look, I accept that if someone really wanted to dissent, there's no way that you could strong arm them to not do so. But is it not the case that there might have been some sort of, you know, collective sense that this was something there where unanimity was pretty important? I don't know. I mean, Dominic,
I completely agree. And one of the questions on the list there is about, you know, was this a sort of tactical triumph for Baroness Hale? I think it absolutely was. I mean, I think it was incredible. She got unanimity, and a few observations about this. Okay, first of all, there's this very awkward bit of reading in the judgment, the weakest part of the judgment, where they'd say this is all about the limits of the power. Okay, it's not about, we're not applying ordinary principles of judicial review. It's a bit of an awkward, then they apply a reasonableness principle. And that is, I think, clearly because they could only get unanimity on the limits of the power being justiciable. And that was how they got the compromise. Another interesting thing about the case is the way Lord Carnwath's dissent in the first Miller case is used and cited as the authority for the principle of parliamentary accountability. I suspect that had a role to play in bringing certain people on board. Another interesting thing about the judgment, which is perhaps less about the unanimity, is the way the judgment was given by Lord Reed and Baroness Hale, when, of course, Lord Reed was about to take over the reins. And so it couldn't just be portrayed as Baroness Hale's judgment. It was about, this is being endorsed by the next president of the court. And one final observation on this. Not long afterwards, Baroness Hale gave a speech. And one of the comments she made in the speech, she was being asked about, you know, attacks on judiciary and so forth. And she said, she made the comment, strength in numbers. And I really think that they felt that they were stronger together. And I think that was a really important and revealing observation that she made. It wasn't, I don't think it was directly about the Miller case, but it might have been, but it clearly was about the Miller case.
It's interesting, isn't it? I picked up your point, Tom, about the way the court at the beginning said, look, we're not interested in the effects of what was taking place, which of course is very important, and the court was right. And yet, I mean, the mood music in the background, I forgot to add another 2 little sort of nuggets which were floating around at the time. It's worth bearing in mind at the time, Downing Street was saying that if the Prime Minister were to be voted out, would be a vote of no confidence immediately prior to the deadline date, the Prime Minister would refuse to vacate Downing Street and resign. One. And the other one was that he would refuse to send the letter that had been required under the Benn Act. Now, actually, the government had some wriggle room on that, because they could go to court and challenge and say, you know, Parliament had got it wrong and the Act didn't say what it said. But I mean, the combination of all those things, and this is where I think the government impaled itself on a spike, which was very visible, was that the government was simply behaving extraordinarily badly. And so the advantage for you in bringing your case is that the factual background was so damning of them. And one, as we all know from as advocates appearing in court, whilst law and facts do need to be kept separate, they do have an influence one on the other when a court is being asked to look at breaking new ground, and that's exactly what happened here.
Yeah, and there's there's a follow-on point to that actually, which is that, of course, the court was very concerned, and everyone was very concerned, that the judgment might just be ignored.
Yeah.
Okay. What was the remedy we were seeking? I mean, we were just asking for a declaration, and the reason we were asking for a declaration was because when we started the case, we were planning to just target the advice that the Prime Minister had given, declare that invalid. We thought that would do. The court was very worried about this because they thought, well, if we make a declaration, the government might just say, well, we've considered it and we're not going to do anything, or we've now come up with some better reasons for proroguing, and you know, there was this really palpable concern that the courts might lose credibility and legitimacy if it made a ruling that, in fact, the government just didn't do anything as a result of. So what did the court do? And this was entirely, really, I think, the court's own innovation. The court fashioned this remedy where it quashed the order in council and it told Parliament that it had not been prorogued. And we didn't want to go that far. We never went quite that far because we were always a bit nervous about it. I think it was completely the right thing for the court to have done, and it was the correct remedy. But they did it very deliberately because it completely cut the government out of the loop. It just meant that the Speaker could say, Parliament has not been prorogued, we're sitting tomorrow, and it didn't throw the ball back into the government's court. And that was precisely because of all this stuff flying around that the government was suggesting it wasn't going to abide by the Ben Act, or it wasn't, the Prime Minister might not resign and so forth. It was a very, very astute and clever move on the part of the court.
So we have a question from Lydia, which was, as it was held that Parliament cannot be prorogued without reasonable justification, in the future, if there was an attempt to prorogue Parliament again, what do you think would constitute reasonable justification? Is it how long's a piece of string, or?
Well, no, I think it's the government. Clearly, prorogation for the ordinary purposes of resetting a new session, fine. Extending in a general election period, fine, as long as it's reasonable. It's not a long period, which would undermine the purpose of the not having Parliament for a prolonged period, for a very long time. And there might be circumstances where a longer prorogation is justified than usual because the government explains why it's doing it and it appears to be eminently reasonable. But I think beyond that, the idea that you can use prorogation in the way that the government tried to do it in August, September of last year, that is dead. It's finished. And any attempt to repeat it will attract the same consequences. So I think to that extent, it's over. I was struck, just changing the subject a little bit, one or two of the questions were quite interesting.
No, please, it's hard to keep track of them all.
Yeah, what about the role of the Queen? You know, if it had been the Queen who'd really done this personally, would that make a difference? Well, in theory, not, because I mean, as Cook's case of proclamations made clear, even the actions of the monarch may be capable of a prerogative power of being reviewed. But I do think it raises an interesting issue, which is that when I was young, my father rather taught me the idea that there were certain areas of reserved prerogative powers of the monarch, which were there to protect our constitution, and which she might, in extremis, choose to exercise. And one of the examples I remember he's giving me was his thought that actually, under some circumstances, a queen could refuse a dissolution because there'd only been a very general election a very short time before. The queen might reject a prorogation because it was being manipulative. Actually, I think that the way our parliamentary democracy has evolved, and above all, the desire to keep the monarch out of politics, means that actually the general view today is that these would not be things which the sovereign would wish to do. And it's all done on advice. And the example of obviously Sir John Kerr in Australia sacking the Prime Minister is another example, in order to put in an administration to hold a general election and force a general election when supply had been blocked, is the sort of thing which a constitutional monarch wanting to act as a unifying force in a country wants to avoid having to do. And that means, I think, that in reality, the Prime Minister's advice will be observed. But interestingly, I think it also does mean that the willingness of the courts to step in and question the way the advice has been granted is probably increased.
Yeah, nodding all round there, I think. Anything from you, Paul or Tom?
I mean, I would agree with everything that Dominic has said. I think, I mean, my view has always been that that certainly in relation to the UK, exactly as Dominic said, I mean, prerogative is, so far as we have a constitutional convention about prerogative, it's clear, which is that the normal the normal position is that a prerogative is very short, and that's usually because the government wants to get on with its business and then wants a new session of Parliament to start because it's got a very busy legislative agenda. So you have 4 or 5 days, exactly as Dominic said, and that's the norm. That's the Constitutional Convention, subject to the other exception that Dominic mentioned, or the other instance where you extend the period of a general election. For me, I mean, I see absolutely no justification, sorry, no empirical evidence in relation to the UK, nothing that gets close empirically to sustaining an empirical, a constitutional convention to the effect that the government can use a power prorogation whenever it wishes, for whatsoever purpose it wishes, for as long as it wishes. It seems to me there is not empirical evidence to sustain that proposition. And it seems to me that in normative terms, or in terms of principle, there's absolutely no warrant for that kind of power. I mean, the idea that the government, for example, you know, there are some instances in the Commonwealth in relation to Commonwealth examples where an executive has tried to use a power prorogation to avoid either a criminal prosecution or avoid some sort of investigation of what the executive has done, which the executive is going to find uncomfortable. It seems to me absolutely, I see no reason whatsoever why a prerogative power, a prorogation, should be able to be used for that purpose. Absolutely none. I mean, let's be clear, as Antoine, who's an expert in this, wrote in her made clear in her excellent book. Look, let's be clear. There's no inevitable reason why a system needs a power prorogation at all. You need a power whereby you can have a break within a 5-year session of Parliament and actually, you know, have a summer holiday, etc., or whatever. But you don't actually need, there's no logical reason why you need what we presently call prorogation. I'm not against it, but it's not an inevitable part of a lawmaking machine which has parliamentary sovereignty at its ground, at its base. And therefore, we have a power prorogation, a prerogative of prorogation for historical reasons, and that's fine. But I think it should be, empirically, it's grounded in the circumstances, from the factual circumstances which Dominic identified, and I see absolutely no reason why it should be extended beyond that. I mean, if you had some exceptional reason why it was necessary to go outside the established norm, okay, then I think the court made clear, the Supreme Court made clear in the discussion of what reasonable justification connoted in Miller 2, it made clear that it would listen to the executive's argument very carefully and give it all due weight, etc. But as Dominic made clear as well, and as Tom made clear, and as we know, in Miller 2 itself, they came with nothing at all, no affidavit at all. So.
Thank you. We've got about 5 minutes left, and we've had a few questions about whether both Miller cases, excuse me, have had an impact on the current political stance, which seems to be anti the role and independence of the judiciary and lawyers generally in this country. Any strong views about whether that has had a big impact, or was it there already?
Well, I mean, I'd be very interested to hear what the others think. But I mean, in a sense, it clearly has. I mean, there's no doubt that those have been big thorns in the government side. But you know, in doing some work on the current review of judicial review, I've had cause to reflect back on some of the things that have been going on in previous governments. And the reality is that governments, not just Conservative governments, I mean, David Blunkett and previous Home Secretaries have long attacked judicial review, immigration lawyers. I mean, it's been a constant and recurring theme for years. Of course, these two cases have been recent high-profile flags to be waived, but I think that there's a deeper issue actually about our relationship, or the relationship between lawyers and courts on the one hand and governments on the other, that bubbles up from time to time.
Do you think it's an inevitable clash of culture then?
Yes, I clearly it's fed a narrative, and the Judicial Powers Project it was run by Policy Exchange, I have no doubt, was latched onto this as yet another example of encroachment on the ability of the executive to do its activities. And of course, the narrative on that is that these are all matters which should be dealt with by Parliament. So it's the relationship. If the executive should be checked by Parliament and held in check and not by the courts. I mean, we had the most extreme example of that when the House of Commons was denounced for preventing, for stopping the government, and told it was useless and dead, and you know, it's our duty, we were told as members of the House of Commons, either to back the government or let it govern, or alternatively to bring it down, which of course we didn't want to do for a variety of reasons in August, September and October of 2019, but quite apart from anything else, because it was thought the general election wasn't in the national interest. So there are contradictory views on that, and the fact that Parliament has actually been shored up by the courts in both Miller judgments in a very, very important fashion, which you might have thought would appeal to people who took the view that parliamentary sovereignty, which has been a much recited topic in the last few years, was important. It doesn't appear to be the case, but I agree with Tom. At the end of the day, this litany of complaint from the executive against the courts goes back a very long way, and I don't think it's a moment of seismic shift at all. Indeed, I sometimes wonder why the government's bothering with the current JR review, because it's got a large majority, and the truth is it's not. The issues which gave rise to both Miller judgments were in some ways fairly unique. I think that, as often happens, some people are trying to fight yesterday's battles. But it is right to say that progressively, as the rule of law extends in this country, we are ending up with a more orderly, rules-based system from some of the executive powers that we had in the past. And there are some people who don't like it.
Yeah, I think I agree with what both Dominic and Tom said. I think the only thing I'd add, not to repeat what they've said, the only thing I'd add is that I think it's really important to consider JR in the round, sort of holistically. And what's clear when you do that, and by that I mean when you either take a year of JR or 5 years of JR or whatever you want, when you look at it from that perspective, the idea that we have judges who are out of control or exceeding the proper remit of JR is ridiculous. I mean, it's just, it does not withstand scrutiny. I could, fill footnotes with Supreme Court cases and Court of Appeal cases and High Court cases where the court goes out of its way to say we're showing respect or deference or giving weight to the legislature or the executive in the policy choice that they're making in this instance. And that's both true under the HRA, it's true under the Equality Act, and it's true in relation to common law judicial review as well. So, the idea that we have a judiciary which is hell-bent on sort of crabbing and confining the executive's every move, I think is just is fantasy.
Well, I think we'll have to draw it to a close there, although this has been absolutely fascinating. And so can I offer my thanks and thanks of all of those watching to Tom, Paul and Dominic. And I'm going to offer you my own little round of applause because, this is the problem with doing things online. Normally you'd get that, that big groundswell. Thank you also to all of our people who submitted questions. We had about 60 of them, so I'm really sorry that there's so many that we didn't get through. But again, thank you to our speakers and thank you all for coming. Just a reminder to our students watching, Charlie and I are going to stay on for 10 minutes or so just to answer any sort of more in-related questions that you might have. But for everyone else, you're welcome to head off and enjoy the rest of your evening. Thank you all very much.
Thank you very much. And thank you, Crawford, for organising it. And thank you to all.
Yeah. Great fun. Thank you very much.
Thank you.
Bye.
Bye. Right, so yes, any questions that you have about anything more to do with the inn? So I know that we had one earlier about dining at the inn. So bear with me a second. So the question was whether there will be any formal dining at the inn once lockdown is lifted, and I can completely understand the desire for that. The questioner makes a point around restaurants and so on being able to open with social distancing. That was, absolutely true until today. They were able to be open, but unfortunately, that is different from arranging a private function, which we were not able to do within the restrictions. Now we were looking at some options for more sort of restaurant-style dining in our halls, but obviously that's had to be put on hold because we're back into sort of lockdown restrictions. Obviously, we're hugely keen to sort of be able to have people come to the inn in person, and to see people again. Doing everything online is not really much fun for anyone. But there are, there have been quite severe limits on what we're actually able to do. Obviously, once this period of lockdown is over, and if you want to come into the inn, you absolutely can. We have been open for lunch in the hall. We have our members' common room has been open for breakfast, lunch and dinner, and obviously the library has been open and remains open, so if you want to come and use that, you can. Now,
got a few practical questions about people disconnecting. Don't worry if you disconnected briefly. We do a Zoom report at the end and we will see for how long you disconnected, so as long as it wasn't for an hour, I'm sure you'll be fine, so don't worry too much if you did disconnect.
So just a comment saying that the speakers were great and that we should invite them to speak about public law once a year. I couldn't agree more. There was question about marshalling. So unfortunately, we've had to close the marshalling scheme for the time being. That is just because the judges are not able to have marshals in court with them, even if they are sitting physically in court. Obviously, actually, a lot of court work is still being done online. There are some courts sitting, but obviously the numbers are severely limited, and so it's not possible for judges to have a marshal there. But for those who applied previously, you should be hearing from us at some point, and as soon as we're able to make placements, we will be making them, and we will go back to those that have already applied, and obviously we'll reopen for new applications. I think I saw something in the chat about the mentoring scheme. The mentoring scheme remains open. Barristers are obviously able to, the mentoring scheme relies less on kind of going to court. Particularly, it's more of a you can have a conversation over Zoom or via email with your mentor. And I know that we've had quite a lot of applications over this period. And so we're kind of working through the applications for that. So bear with us. But if you applied more than a few weeks ago and you haven't heard back, then it's worth getting in touch with us again on that. You can email the education inbox for that one. This question gone in the questions and in the chat, so I can tell someone's really concerned about this, who wasn't able to attend a face-to-face session in March because it was just before the first lockdown started, and they were concerned about travel. So it shouldn't affect your call as long as you've done enough qualifying sessions to be called. If you need to apply for a waiver for that session, then you can get in touch with Rani for that.
Just another practical point, sorry, Faye.
Yeah.
Some people are asking about when they'll be credited for today's session. Do give us a little bit of time because they are done semi-manually. I won't go into too much detail, but it won't be immediately done tomorrow morning. So do give it at least until Monday or Tuesday. It does depend on how quickly we can get round to manually going through the list and then checking it against your record. Fine.
Yeah, bear in mind it's about 350 people on this session tonight.
Just this one session, yeah.
Yeah.
And we have one on Tuesday as well.
And we do get a very big spreadsheet from Zoom, but what it also does is it puts an entry in every time somebody drops out of the session and comes back in. So it does take a while for us to just work through all of that to verify that people were actually here. And then there is a process to actually get that onto your record as well. So yeah, do be patient with us. It does take time.
It doesn't help either when students log in as Fred Astaire rather than their actual name, which I did notice somebody had.
I don't know if maybe that is Fred Astaire, but
no, it wasn't.
Yeah.
But don't worry, that person, I've made a note of it. Okay.
It is an excellent point, though. It's much more helpful to us if you log in with the name that we know you by. There's a question about somebody says they've only booked 3 qualifying sessions for this term and will more become available, so they can book more this term. There are still some places at the sessions for this term, as far as I'm aware. You should also keep an eye on the booking system. Just we will occasionally get places come up. But we're not putting on any additional sessions for this term. So everything we have available has been advertised on the list already. But yeah, it's there will be a similar number of qualifying sessions available next term as well. So we obviously do plan our qualifying sessions around our student numbers, so we provide more than enough opportunities over the course of the whole year. Just seeing if there's any Any more that we haven't covered yet?
Residential weekends.
Will
there be residential weekends? Well, we would normally hold 2 residential weekends this term, but obviously we've had to cancel them. We did push them back to next term, but it was still not certain whether we will be able to run those. And obviously we just have to base it off the government guidance and the venues guidance as well. If we can run a residential weekend, we will, because we do understand how popular they are, and they are also our favourite events to attend as well. But yeah, we'll just have to play it by ear, I'm afraid. But we will let you know, and if one is available, then we will put out the normal information and have the ballot as usual as well. But yeah, we're just going to have to play it by ear for the time being.
Yes, you are absolutely allowed to leave now. You see that coming through in the chat. Off you go. If you don't need to sit here and watch us answer these questions, this is really just to, you know, we do always get some questions during these sessions which don't relate to the topic of the session, but you know, we want to give an opportunity for you to ask them and us to answer them. There is somebody who said they didn't get the link for this this event. That's a bit worrying. So could I ask that you email the booking email address just to check that you were definitely, that we had your sign up for this this event. We've had some issues with our booking system, which is very clunky and is falling over on us this year, but we are due to put in a new one in January. We're working on it now. It's due to go live in January, so hopefully it will be better. But yes, if you do have any, if you ever think you've signed up for an event and you don't receive the information, then please do get in touch with us to let us know, so we can check that you're definitely on. Yeah, question about scholarships, Charlie.
Yeah, so you've only added 1 reference, if it's the same one you're referring to, Faye. We absolutely do need 2 references. You shouldn't actually be able to submit your application without 2 references submitted. At least one of those references should be an academic reference, unless you completed your most recent degree over 5 years ago. But you can't submit the application without having 2 references uploaded. So you definitely will need that. And just a reminder, the deadline is tomorrow at 1 o'clock. So you haven't got much time if you need to get that second reference in.
And then I think we're gonna wrap it up, but shortly. But just 2 more quick ones. So about next term. So first thing to say is that no, I'm afraid the bookings won't open early in January because of our new system going live. So we need to make sure that gets amended. You will be told when it's, thank you, Charlie, you will be told exactly when it is going to open, but because it's a new system, people will have to register for the new system. So we've put back the start of our qualifying sessions to February, and so bookings are going to open towards the end of January, but we'll confirm those dates both on the website and via the students newsletter. And then the second question there was around whether we know yet whether events are going to be face-to-face or continue to be online. I think, you know, there's kind of there'll be our take on it, and then there'll be what we actually want to do. I mean, we're very keen to be doing things face to face when we can. The issues, obviously, we have with the restrictions from the government so far have been that gatherings have been at quite small scale, which means that it's not really feasible for us to run qualifying sessions where we have to limit participants to, you know, to only sort of 20 or 30 people at a maximum. I know that there are exemptions around education and training, but we don't necessarily qualify for those because we're not a university or a college. So I think, I mean, what I can say to you is that we want to. I personally think that at the minimum for next term, there's going to be a combination of online. You know, if we're able to do any in person, we'll still be doing some online things as well. But yeah, we're keen to get back to in person when we can.
I've had there's a couple of questions about will there be more advocacy and wellbeing sessions. Yes, we will make sure that we provide plenty of each theme of qualifying sessions, so don't worry. If you didn't manage to get onto a certain theme this term, there will be more opportunities next term for each of the themes, and then even more opportunities for the following 2 terms as well. So don't worry, we have done the maths and we have made sure that there are enough opportunities for everybody to get their 10 or 12 qualifying sessions, but then depending on which one you're doing, by the end of the academic year. So don't worry.
Okay, I think we're gonna have to log off now and go and have some dinner. But thank you all very much for coming, and I hope that you found it interesting and enjoyable, and that, you know, at the end there we were able to answer as many of your questions as possible. All right, have a good evening or whatever time it is wherever you are.
Enjoy the fireworks.
Enjoy. Yep. Bye then. Bye.